All right, folks, before we head back to court, I want to bring back in our guest still with us, attorney Eric Subin. Eric, here's my question, Eric. You know, a lot of people online have been wondering what effect the choice by this defendant to basically give a narrative and go it on his own might be having on the jury. Do you think they're looking at this and wondering what's going on and holding it against him? The judge gave no instructions, no really anything to the jury to say, hey, you can't hold it against him. This is just the way he's decided to do it. Really said nothing to them at all.
I think he is the best possible witness the prosecution could have asked for. Obviously, we can't see the jury, but I think that he is essentially gift wrapping a guilty verdict on murder one for himself with this testimony. It's absolutely terrible. His defense would have been much better served by going for reasonable doubt and trying to poke some holes in the prosecution's case as opposed to conjuring up this bizarre conspiracy theory involving assassins and frame jobs. I cannot imagine that this jury is buying this.
But I have to say this, as an attorney, we know that he has the right to choose to testify or not, but it's almost like he's coming up with his own theories while he's on this stand. What do you do as defense counsel? Is there anything you can do, or at that point, do you just have to let your client go?
I would object. I would try and throw the prosecutor off his game as much as possible, try and disrupt his flow. The prosecutor's got total control of the courtroom right now. I would object until the judge admonished me. I would find any grounds I could to object just to stop this, because it is a bloodletting at this point.
Oh, that's such a good point. You're right. It is going and going and going, and not in the defendant's favor.